Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Raymond Sheffield. And Ray is an attorney specializing in trusts and estates with his own company, Sheffield Law Office in San Jose, California. He's been a lawyer for 11 years. He received his JD or law degree from Santa Clara University and an LLM degree in estate planning from the University of Miami in Florida. Ray tells me that he loves the role of counseling clients for their estate planning. In addition to his law practice, Ray is an adjunct professor in the Golden Gate University LLM tax program. And Ray and his wife live with their two adopted daughters, ages 4 and 6, who are from Russia in Almaden Valley, San Jose, California. Today, Ray and I are going to be talking about estate planning for retirement accounts. So before we get started, I want to caution our viewers that we are discussing issues in a very complex area. This is just a starting point for a bigger discussion with your own attorney or tax advisors. And also, we're mostly addressing issues from a federal and California standpoint. So here in California, for example, we have community property. That doesn't apply in other states. Viewers in other states should seek advice about their local laws. Ray, thanks so much for joining me today.
Well, thank you for having me, Mike.
Okay. Why are retirement accounts a special class of assets for estate planning?
Well, Congress has kind of made them that way.
Okay.
They're tax issues when you take the money out of those accounts, and they changed the rules in 2001. And still, a number of advisors are not familiar with those rules, but they changed how you can leave those accounts and be able to get some of the benefits for your kids out of those accounts. But you got to follow the rules. Mm-hmm. And so, because most of the time we just name a beneficiary on the account and that takes care of it, most people don't really think too much about, well, what is the impact on my estate, what's the impact on my kids, and what's the tax impact, for them as well when I die and these accounts pass to somebody else.
Okay, so we'll get into more details related to this. So what are some considerations when you even choose a beneficiary for a retirement account?
Well, there's a number of considerations as far as, do you want them to have a lot of control? Do you not want them to have a lot of control? If you give it to your spouse and your spouse remarries, do you want your spouse to be able to give it to the new spouse, mm-hmm. or to future children they may have? Mm-hmm. So there are a number of issues that relate to whom you should choose to be your beneficiary, and then how much control you let them actually have over this account. Mm-hmm. For most clients, this may be the largest asset or the second largest asset outside their home that they have in their estate. And so it can make a significant difference and an impact depending on what choices they choose.
So for example, one thing that people don't think that much about is whether they want to leave a charity as a beneficiary for a retirement account. And these accounts, especially a regular IRA or a regular retirement account, can actually be loaded with ordinary income. So might a charity actually be a good beneficiary?
Charity is always, if we're going to leave anything to charity when you die, the retirement accounts are the best place to take that money, because the charities don't pay income tax. Your kids or your spouse always pay income tax on the distributions. So while they may get 60 cents on the dollar, the charity gets a whole 100 cents. Mm-hmm. And so that's always the first place we want to take money from if we're going to give it to charity.
Okay. What about younger people compared to older people as a beneficiary?
Well, certainly when we talk about being able to have this money last over someone's lifetime, right? So the IRS says that you have to take money out every year. Mm-hmm. So when you die and you leave the retirement plan account to your kids, they have to take money out every year. Well, if you're older, you have less life expectancy, So you have to take more out every year than if you're younger, right? Where you have more years, therefore you take less out every year, which means you also get to grow the account for a longer period of time and stretch out those benefits to that younger generation. So when we're looking at how to leave money, we're always looking at leaving it, hopefully, to the younger people rather than just giving it to everyone or giving it, to, for example, my mom, who's much older than I am, and therefore the account disappears much faster.
Yeah. How about people who are in low income tax brackets compared to other people?
Well, certainly, for example, we have a client who's a cardiologist, and he has a son who's a cardiologist, and he has a daughter who's a school teacher. Now, he loves them equally and wants them both to get half of the estate. But the teacher isn't anywhere close to the same income tax bracket as the cardiologist. So in doing calculations, right, we can leave the IRA money to the teacher, right? And because she's going to pay less income tax than the cardiologist, it's actually a better asset for her than it is to give to the cardiologist, who pays a much higher percentage in tax.
Okay. What does stretch out mean?
Well, stretch out is the term that we use to describe the ability to defer paying the income tax, right, on these accounts by being able to keep the money in the account long term. So everyone pretty much knows that when you have an IRA or a 401k, you can't take money out until you're 59 and a half, right? And then once you turn 70 and a half, you have to start taking distributions. When you die and you leave the money to your kids, right, they have to start taking distributions out every year.
Right away, yeah.
So being able to stretch it out is creating a process that allows for the beneficiary to take that money out over time, over a long period of time, rather than having to take it out all at once, or let's say within 5 years.
Yeah.
Because then it's subject to tax right away, and they don't get the benefit of all that tax deferred growth.
Right. Okay. So maybe you can review again a little bit of the rules for required distributions.
Well, so, for you and I with our plans, right, or anyone else, once you reach 70 and a half, you start taking a minimum distribution, right? And that distribution goes up a little bit every year as the percentage gets higher. Well, the same thing applies for beneficiaries. The difference is that we establish that distribution amount in the first year, and then from a percentage standpoint, we just add one it's a fraction. I don't want to get too technical.
Actually, we subtract one.
We subtract one,
yeah.
So
if you had a life expectancy at the death of the person, and let's say it was 10 years, just for an example, then the next year you would divide by 9, and the next year after that 8, and so forth.
Yeah, so it grows much faster. You have to take the money out. What we tell people is generally for your beneficiaries, all the money will come out by about age 85. Because that's around where life expectancy is going to be. Whereas for you, as the person who started the plan and put the money in the plan, you may still have money in this plan well into your 90s if you survive that long.
Right. Okay, what about estate planning considerations for a surviving spouse as it relates to these types of plans?
Well, this is something that most people just, as a general rule, don't really give much thought to, but can make a huge difference. For example, if you name your surviving spouse as the beneficiary of the plan outright, they can do what we call as a rollover, where they become the participant in the plan, and they basically become you, using their own age to determine, their issues. Well, there are a couple of problems with that. One is, well, what if your spouse remarries, right? They can now leave it to whomever they want. So you haven't made sure it goes to your children.
Yes.
Secondly, you may want to have it in a situation where the spouse has to use up some of your estate tax exemption. Now that's not as big a deal now because we have portability, and we'll go through that in another topic in this series, I'm sure.
Yeah.
But you may want to make sure that you're using up estate tax exemption or equalizing the estate tax exemption for the spouse, and not just moving money into somebody else's estate. Mm-hmm. And then, of course, we do that by putting properties in trust. But the other thing is, what if your spouse is young?
Yes.
What if they're a lot older than you? So both of those things can make a difference after you die as to whether or not the spouse should actually do the rollover, even if you're okay with them doing it, whether they should do it.
Right. So that's a really important point. I had this come up actually with somebody. So this is, again, it gets to the heart of self-administration. People go out and they try to take care of things themselves, and then they show up on the attorney or accountant's doorstep later. Usually it's the accountant's, and then the accountant drags them to the attorney. So in this particular case, one of our clients passed away. His wife immediately rolled over his account to her own name. And then, so she comes to me, or to us, at the time it was a CPA firm, has a partnership. And I said, "What did you do this for?" And she said, "Well, what do you mean?" I said, "Well, what's your age?" And I think she was like in her mid-40s.
Mm-hmm. Yeah.
And I said, "Well, I don't know if you realize it, but now you cannot get much access to this money because it's in your name. You have to take it according to the rules for your own account, which means that you can't take it out without penalty before age 59 and a half unless you take it out as an annuitized amount. You can't take it as a series of substantially equal payments over your lifetime. But that means you get a little bit. You don't get a lot." And she said, "Well, I've got all these bills that I've got to pay." I said, "You got a problem. You're going to have to go back to work." So
It is a real problem. In our office, I would say 30 to 40% of the surviving spouses come in having already done transfers of these assets because they called Fidelity and the person on the phone said, "Well, you have to do a rollover. And here's the paperwork to do that," right? Or they went to their bank who sold them the mutual fund that they put the IRA in, and they say, "Oh, well, you have to do a rollover." Everybody knows that you can do a rollover, but they assume that you should. Mm-hmm. And to give you another example of where you really should not be doing a rollover, certainly if you're under 59 and a half, you can always take money out. It's that 10% penalty that really gets you if you're under 59 and a half. So first, if you're under 59 and a half, do not do a rollover. Mm-hmm. But secondly, if the deceased spouse is younger than the surviving spouse, right? When you do the rollover, we're now using the surviving spouse's age to determine minimum distributions. But the surviving spouse, if they do not do the rollover, can defer any minimum distributions until the deceased spouse would have reached 70 and a half. So let's take, for example, a client who dad is 65, mom is 69, and dad dies. If mom does a rollover, she now has to start minimum distributions when she reaches age 70 and a half. Mm-hmm. Had she not done the rollover, she could have waited for dad to his age to have reached age 70 and a half, right? Before she would have to even start taking minimum distributions. And that allows, of course, for much more tax deferral, much more potential growth, and a better economic result for the surviving spouse and the family.
Right. So basically,